Americans. Good morning, guys. This is CJ Holmes, founder of Homeowners for Justice, your host for Weekdays Live today. And today is an interesting day. A lot of things have happened. Outrage is growing, and that's a good thing. We need to understand it. We need to understand ourselves. We need to understand where we can head. And that's what I view part of Weekdays Live to be, a daily consciousness of what is going on, what does that mean for us, how can we use this, and how can we capitalize on it? How can we protect ourselves? How can we help other people? How can we save our homes and our country and ourselves? So the very first thing I want to bring to your attention, and like I said, I get links from just all over the country. I totally welcome that. I'm so thankful that you are doing this for us, because it is for us. It's not just for me, it's for us. And I believe we need to see what I'm going to be showing you, because the more we understand about ourselves and our neighbors and why we might be feeling like I keep yelling and nobody's listening, we'll better understand that, and we can use these understandings to move the effort forward. And let's never, ever, ever forget, fraudulent foreclosures are just a symptom. It's a horrible symptom. It's ruining millions of people, and it's bringing to light all the fraud of the banks. We're going to see that in a minute. But the fact of the matter is, it's just a symptom, and we need to keep our homes and we need to protect ourselves. But I think worse things are going to be coming there. And so we need to recognize those. We need to get our heads out of the sand, and we need to think about what can we do to fix them. And I'm bringing on the show tomorrow and Friday. Every day I'm going to try to bring in more information of what we can do to fix the system and also to protect ourselves, because that's what we really have to do. This chain of events is already in place. And so our awareness is one of the strongest protections we currently can have. So I'd like to start today with this link. It's called Normalcy Bias. It's just one of 58 or so episodes that this gentleman is doing under Truth Never Told. And I found it extremely helpful for me. So take a watch.
It ain't what you don't know that gets you in trouble. It's what you know for sure that just ain't so. Mark Twain. Normalcy bias is when people underestimate the possibility of a disaster and the possible effects of that disaster. Everything is fine today. That is our illusion. Voltaire. Normalcy bias is a direct result of people failing to question things, blindly obeying authority, or failing to apply logic to a new set of information. This ignorance is bliss mentality is so dangerous during times of upheaval, as they fall into a false sense of security. This leads to no urgency to take massive dramatic action in the face of crisis. History has shown over and over again that just when things seem so peaceful, it is only because that they are so controlled. This is a natural precursor to things exploding out of control. The worst lies are the lies we tell ourselves. We live in denial of what we do and even what we think. We do this because we're afraid. Richard Bach. Normalcy bias is not only true on a personal level, but on all levels of society. This is a major cause of systemic failure, since those that are in power assume that they are masters of the universe and that everything is fine. Normalcy bias is the idea that since disaster has never happened, it will never occur. Or in the case of those who own our paradigm, they believe that they have the power to manage disaster with the power of the media, military, or the printing press. The problem of the crisis we are going to face is going to be unlike any other in human history, with the worldwide, mathematically inevitable collapse of currencies and paper assets. Those that are in power think that it's going to be another 2008, and that if they just print enough money, they can get their way out of anything. The money that they're going to print will actually cause the major shift in paper assets. The people this time around will realize that they cannot trust anybody. The markets are rigged, segregated brokerage accounts are stolen, titles on properties are unclear, and most importantly, the currency in which all these assets are measured in has terminal cancer. This will result in quadrillions of paper assets trying to rush into anything that's real. This rush of digital fiat cash into anything that's real will result in the system being broken. Those that are holding any real assets at the time of the crisis will eventually not accept any paper for their real assets. When this happens, it will disrupt every aspect of your life and neuter any control that the elite may have over the situation. This normalcy bias also has dramatic effects on the people even after a new reality smacks them in the face. People with a normalcy bias will have an incredibly hard time reacting to a new reality. They will not be able to question what they see with their eyes with logic. They cannot believe that they, or those that were in power, were so wrong. They will waste precious time dealing with the fact that they were so wrong, and this often results in self-destructive behavior. As people do come to terms with this new reality, it will naturally lead into the anger phase of the awakening, where the emotional response from those that are completely unprepared will override any logical response from the elite, or anyone else for that matter. I must not fear. Fear is the mind killer. Fear is the little death that brings total obliteration. I will face my fear. I will permit it to pass over me and through me. And where it has gone past, I will turn the inner eye to see its path. Where fear has gone, there will be nothing. Only I will remain. Frank Herbert. The individual is handicapped by coming face to face with the
So, the point is that we are in denial, and the system thinks it can fix it. Did you catch that? The people that are in charge, so we can think of those folks, Bernanke, the federal government, they can either fix this with printing more money, using a military solution, and controlling the populace. And the bottom line is, it will blow up on them. And we need to understand that. So here's the symptoms. You got to understand that we don't want to really recognize what is going on. This link was just sent to me. It's classic, because we're going to hear in the very next minute about a discussion with Elliot Spitzer and on MSNBC about these outrageously, obscenely wrong foreclosure settlements. And the fact that the OCC is not only a willing participant, but a supporter and instigator of this, the corruption of the federal government. That's what we're facing, and we need to just admit that. And then we can figure out how to protect ourselves and to move on.
Big, surprising, and welcome news on gun legislation today as I speak to you, and a trial in Philadelphia that could be the beginning of the end of football as we know it. But first, the most shocking piece of news today is this seemingly innocuous document. A simple, sterile page, a printout of a spreadsheet with numbers. Boring. But what the numbers represent is a massive nationwide crime scene. No, I mean that. That document is a summary of widespread and systemic error, malfeasance, and reckless lack of care on the part of our nation's biggest banks. What those numbers show are banks foreclosing on military service members who are entitled to relief, of banks foreclosing on homeowners who had been approved for a loan modification, of banks even foreclosing on homeowners who were not behind in their payments, not in default, current. In fact, amazingly, on that sheet of paper is the number 53, which denotes there are at least 53 documented cases of homeowners who were completely current on their payments being successfully foreclosed on. Not just having foreclosure proceedings initiated against them, but these are people who are making their payments, paying their mortgage, and actually have their homes taken from them for no reason. According to the findings posted just today by a federal bank regulator as part of a settlement agreement with a number of major banks, between 2009 and 2010, foreclosure proceedings that were wrongful or in some way contained bank error commenced against nearly 4 million homeowners. About 30% of foreclosures had those being foreclosed on had to battle potentially wrongful efforts to seize their homes. 30%. More than 244,000 eventually lost their homes. Today, the Office of the Comptroller of the Currency, the regulator who compiled these statistics and came to its settlement with the banks, it was supposed to be announcing good news. It was supposed to be announcing money to those who have been victimized by the bank's practices. But given the scale of the deception and error, the amount of money on the table for those who've been victimized is in most instances cartoonishly small. A pittance compared to the billions of dollars about a dozen banks and their affiliates likely saved by getting this settlement deal. For example, there's the category of homeowners who were foreclosed on, that is, successfully kicked out of their homes, even though the borrowers had worked out a new payment plan with their bank to stay in their home, and they'd stuck to it. There are 234,000 of them. Another 865,000 were in the process of foreclosure, even though they too had gone to the bank and worked out a new payment plan. That, by the way, is euphemistically known as dual tracking, where a bank is processing your loan modification while also simultaneously pursuing foreclosure against you. A better term would simply call it double dealing or double crossing. So the 1,099,000 victims of dual tracking get $500 each. $500. It's a number so hilariously low, it has spawned Alexis Goldstein's What You Can Buy for Having Your House Stolen. One of her suggestions, this 2-meter dome for those homeowners lucky enough to get $5,000 from the settlement. Which brings us to our next notable category, homeowners in which the servicer initiated or completed foreclosure on a borrower who was not in default. If the foreclosure was completed on a homeowner who was not in default, $125,000. Now, $125,000, that is a lot of money. But that's $125,000 for taking your home away from you without any justification. These are people who did nothing wrong. They were not in default. They were current on their payments, and their homes were taken. In any other context, we would say they were stolen. They'll get $125,000 for their trouble. The outrage of that category matched perhaps only by this one. Servicer foreclosed on borrower eligible for Service Members Civil Relief Act. Translation, wrongfully foreclosing on active duty members of the armed forces. It's a criminal felony. The banks merely pay out $125,000 to those victims. All the other awards in all the other categories pay out mostly nominal amounts. Many of the 3.5 million homeowners who received some kind of payment were supposed to get an independent review from the government. But the Federal Reserve and the Office of the Comptroller of the Currency, or OCC, punted. They punted because this independent review process to look into a system that was so deeply flawed and messed up that everyone around the country was scratching their heads, this deeply flawed system, as the New York Times characterized it. Instead, the OCC engineered a mass settlement. They got halfway through it and they said, you know what? No. Let's come to the table. What should the banks pay? And that is represented by this document. What it represents is, in any intuitive sense, the evidence of a crime wave that once again the banks will not have to answer for. Joining us from Sacramento, California is Faith Bautista, who is the victim herself of a wrongful home foreclosure in 2009. At the table, Elliot Spitzer, former New York governor and attorney general, and Alexis Goldstein, former vice president at Merrill Lynch and Deutsche Bank, now an Occupy Wall Street activist. It's great to have you here. Faith, I want to begin with you as someone who, if my understanding is correct, would qualify for the terms of this settlement. As someone who was wrongfully foreclosed on, what is your reaction to this big news today about what this settlement looks like?
Well, as a victim, I'm happy to receive something because I have applied since January of last year, and it's now April. I haven't gotten anything. And if I waited for their system without OCC unplugging the plug, I probably would not get anything. So to me, whatever I would get, I will be very happy. But I'm hoping I will get more than $500.
Are you looking at $500? Is that what you're looking at for being foreclosed on incorrectly, wrongly?
You know, at that time in 2009, I was with the World Savings, and I have a pick-a-pay type of payment, and I lost my job, so I can only pay the minimum, and then after a while, I really cannot pay, so I have like $12,000 in arrears. I asked World Savings, which is now U.S. Bank, to help me with the loan modification. In 2009, there was no program. So I was wrongfully foreclosed because for $12,000 in arrears, put 20% down on my house, always been a great borrower since 1986.
Yeah.
To take my house away, you know how devastating that was, being a single mom and having 2 kids and being taken my house away? That's pretty sad. So if I need to get more than $500.
Alexis, how did we get there? How did we get here, right? So there's we have the housing bubble. Okay, the housing bubble, everybody goes out and they get mortgages, and then the mortgages all blow up, and the blow up makes the financial crisis. And what blowing up looks like on the backside is that banks are foreclosing left and right. And they're foreclosing on so many properties, they cannot deal with how many properties they have to foreclose on. And then what happens?
So the OCC, which is one of the bank regulators that used to be responsible for what's called mortgage servicing, which is just getting your monthly payments and giving you a loan modification if you need one.
So I have a mortgage, and there's someone I send a check to every month, right?
That's your servicer.
That's my servicer, okay.
Right, so the OCC is in charge of regulating them. They look really bad because there are all these people being wrongfully foreclosed on. There was the robo-signing scandal where the banks were fraudulently filling in documents. So they're like, what can we do to make ourselves look better? What can we do to make the banks look better? And what can we do to restore faith to the mortgage markets, which was one of the stated goals of this thing called the Independent Foreclosure Review that we've just seen the settlement for. So
there's all this news that sweeps the country. This robo-signing scandal is a huge thing, right? And it turns out the banks are saying, we're foreclosing on you. And when you say to them, wait a second, you're foreclosing on me. Do you have the documents to foreclose on me? They say, yes, this document right here. And that document right there isn't the actual document you need. In fact, it's an affidavit that's been signed by a robot or by someone they've been paying minimum wage to just sign documents saying, oh yeah, don't worry about it, we have it, right? Huge scandal, blew everything up, was in the Wall Street Journal, and everybody looks embarrassed. So the OCC says, okay, we're going to conduct a review.
Right, so they do this in April 2011, just a few months before the CFPB comes on board. The CFPB would have done this if they had just waited.
Okay, alphabet soup. The CFPB is the new Consumer Financial Protection Bureau, which is part of the Dodd-Frank legislation passed by President Obama and by the Democrats with a little bit of Republican House in the House.
So one could argue that the OCC, the Office of Controller for the Currency, did this because they didn't want the Consumer Financial Protection Bureau under Elizabeth Warren to be in charge of this, because they have been known to be very kind to the banks, they have been known to bury the banks' bodies, and they have been known to lie on behalf of the banks, which they did in this independent foreclosure review. Recently, they came out with a number that said 4.2% of borrowers had an error.
Right, so they said, we did this whole review, and then this got huge headlines. Oh, don't worry, it's only 4.2% of the people have an error.
But just last week, the government has an auditor. It's called the Government Accountability Office, and they basically said that the OCC did not come up with a systemic methodology. They didn't tell each bank how to figure out where there were errors. They didn't have a series of consistent categories, and they basically found out that there was no way that you could have figured out one consistent error rate across all of the banks because there was no consistent methodology. It was like reverse engineered to make the banks look as good as possible.
How surprising is this to you, Elliot?
Look, not at all. 2 points. First, the amount of money involved in the totality of the settlement, and this is why Faith only gets $500, is less than the Treasury Department gave to Goldman Sachs to cover Goldman's exposure to AIG, which is over $12 billion. Nobody said anything. Goldman just got a check for $12 billion. All the mass and wrongful foreclosures in the country, only about 2/3 of that. So the amount of money is insanely low. Two, let's put the OCC in historical context. It is the paradigm of a broken, fraudulent regulatory body. It has been in the back pocket of the banks historically. 3 chapters to this. It's tragedy. One, pre-crash. In 2003, I and all the other AGs went to court to try to open up the subprime scandal. The OCC came in on the side of the banks to stop us. We had to litigate all the way to the Supreme Court.
Against the regulator.
Against the OCC, they were covering for the banks. Chapter 2, the OCC opposed mortgage write-downs, the sort that would have benefited Faith, that would have saved the economy. The OCC said, no, we're here to protect the banks, not the entirety of our economy. Right. Chapter 3, what Alexis just described, their absolutely grotesque failure to do an appropriate review. So the OCC should be eliminated. Wipe it off the board.
It's just a whitewash. When they said the 4.2% error rate, they were lying. It was an unabashed lie.
All right. Well, so Morris Morgan, who's from the OCC, says to the American Banker, do I think there were a significant number of people who were foreclosed on where the banks did not have legal right to foreclose on them? At this point in time, I don't think that was a significant number. I guess my question to you, Faith, is do you feel that there is anyone who has your interest at heart as one of the people who are represented on the spreadsheet, as one of the statistics? Is there anyone in Washington you feel has your interest in heart who is looking out for you?
Yes and no. Tom Curry, he inherited this problem, just like President Obama inherited this problem. So he only can do what he can do. He unplugged it, and to me, as a homeowner that was a victim, I'm finally going to get something. My problem is $3.6 billion that will all go to all of us that were victims, and the independent auditors are getting $2 billion. I really have a problem with that. They're getting more than half.
Let me explain that. These are the consultants who were hired to conduct this big review. They're walking away with $2 billion in fees for conducting it. The sum total amount of cash that is going to the people that were wrongly foreclosed on is $3.6 billion.
Hired by the services, we should point out.
Yes, hired by the banks
not even hired
themselves.
as independent, the word independent, but not really independent.
So just really quickly, so say you're a borrower who's going to get $500. There was a consultant hired by a bank who was paid $250 per hour to review your file, and they walked away with $10,000 to look at your story of tragedy, and they now get $500 to the consultant's $10,000.
Quickly, and finally, Elliot, why do the banks skate away with paying money and then going off to do it again? What has to change in that?
We heard it from Eric Holder a couple weeks ago. We can't possibly bring a case against the banks because it would do bad things to the economy. A flawed premise that too big to fail has become too big to prosecute, too big to indict, too big even to exact a meaningful penalty. They walk away without even admitting wrongdoing. The whole paradigm of prosecution has to change.
Yeah, and no amount of writing checks is going to change
Money
that.
doesn't do it.
Former Governor Elliot Spitzer, Alexis Goldstein, and in Sacramento, Faith Bautista. Thank you. All right, what?
So there you have it. That is the point, isn't it? It's the paradigm of justice, of actual prosecutions that make a difference. And this is the point. This is the point. The federal government, the prosecutors, they've been bought off. And when our Department of Justice at the federal level will not prosecute federal entities, it's very difficult for everyone else to pick up that slack. Now, for those of you that are researchers, in particular, I was thinking of you, on this link, here's more secrets and how to find out about patents. We've talked about that just briefly. This is more bank secrets. This is what they do. This is how they do it. And this is how we need to recognize what they're doing and then how we may be able to stop that or fight back or make sure they can't in the future. We have to be thinking in the future, looking at what's being done so that we can set a new paradigm. So this is how they've done it. This is a patent. This guy here on this author talks about how he searches for patents. And what's really fascinating is about the assignments, patent assignments. And so I just wanted to point out a couple of things here that I thought were noteworthy in this article. Countrywide assigned patents to Bank of America. And he talks about how he used that tool and got the result. And it turns out that, for instance, the first patent number listed, he gives it, filed in March 2007, was 5 months before the date B of A acquired Countrywide. And Countrywide assigns these patents to B of A before they're, as they're taken over. Now down here was another interesting article, an article about computerized robo-signing. Remember, that's forgery and false notarization. That's what robo-signing really is. And this person writes, the banks patented every step. In the office, there were thousands of patented schemes that identify shadow banking as if to legitimize the system. Many researchers feel that there is so much debt. Now, this comment is 600 trillion. As Neil said last week, 1.2 quadrillion. And we've already heard people say quadrillions. This fiat credit is just mushroomed out of control. They can just create as much as they want. I like the title of the book. I have not read it. It Takes a Pillage. That's an interesting title. But they have to continue trading to maintain cash flow. And this is a key point. I want you to remember, stick it in your head. If they ever stop trading, the system will collapse. So they have to continue trading and they have to continue adding. Otherwise, it drops. It collapses. There are even rolling, get this, occupied foreclosed properties into short-term bonds. Now remember last week whenever we talked about it, I showed you the patent on loan applications, and they were securitizing loan applications whether they were approved or non-approved. So they're securitizing non-approved loan applications. So they're securitizing foreclosed properties into mortgage-backed securities, into bonds. Congress has ignored regulating them, probably because they've bought into the The line, the banks have been selling this line. They've been selling Congress. It's a two thing. They pay them off for campaign funds, and then they will scare them into working with the banks. They'll say, hey, if you don't do this, we're going to bring everything down. And it's going to look bad on your watch. And so then Congress goes, oh, I don't want to do that. And they have nothing left to fight back on that line with. And so they cave. And so this would ruin the financial future, of course, of all of the heavily invested congressional leaders and judiciary. And of course, so you have that too. The judiciary, the Congress, they think they're looking at the revolving door. Remember, I think I showed a stat that when on the average, when the senator or staff leaves the Senator, House of Representatives, the average increase in their pay was like 1,472%. I mean, obviously, this is something that people are thinking of. So this little article, I'm sure that will be of great interest to several people. And I also wanted, they pointed out in that article here, and I've just pulled this up as a link, that the four companies, there's four companies that together provided most of the 2012 earnings growth in the S&P 500. So look at this. The top 10 contributors, you've got Apple, you've got Bank of America, BAC Servicing, you've got AIG, and you've got Goldman Sachs. And those four is over 50%. It's almost 60% of the growth last year. And then the rest of these up here on top, these are all, well, there's IBM, but then you've got bank. And then everybody else is over here. So whenever you see statistics about the growth is up, stock market is up, just remember it's only up for the favored few. It's not up for the people. And this is something that we need to recognize and realize. Now, I'm going to talk now about Ellen Brown's new article. She's involved in public banking. I think she's one of the main proponents of public banking. She writes articles all the time about it, well known. And she has written this article. It's a pretty scary article, and it ties in with what I've been telling you earlier this week. And remember, we got to keep the houses, but we need to keep our money too. And we need to keep our investments, because the more they take, the weaker the people become. So the less they can take, the stronger the people. So please try to share this with everybody. This live stream is for the nation. This is for every one of us. Whether you're facing foreclosure, whether you are paying your loan, whether you own the property free and clear. Every one of the people in the country, including Ellen, including Spitzer, including all these people we see on these shows, every one of them too. We're all facing this ourselves. And this is a pretty scary derivative burden, is what I call it. She is pointing out the super priority status of derivatives. So if you think it was bad, it's actually worse. And what actually happened is that, I'm going to read just a couple of sentences here. Derivatives now have super priority status in bankruptcy. And the Dodd-Frank Act precludes further taxpayer bailouts. So they won't allow the government to bail out the banks on derivatives. And we already have been talking about these derivatives frequently. So in a big derivatives bust, which we know has got to mathematically happen, it's just when it's going to happen, not if, there may be no collateral left for the creditors who are next in line. Now, she talks about the shockwave that went around the world with the haircut that Cyprus depositors took. And she's calling it a bail-in. That's the bail-in for the two bankrupt banks in Cyprus. The bail-in is a quantum leap beyond a bailout. When governments are no longer willing to use taxpayer money to bail out the banks that have gambled away their capital, and the banks have been just a casino house, not caring because they felt they were going to get bailed out. And they've been right. So the banks are now being instructed to recapitalize themselves by confiscation. and they're taking the funds of the creditors, those innocent depositors that were putting their savings into the bank accounts, thinking it was a secure place. Now, the fact is, she's point blank agreeing and stating that the Cyprus bail-in was not a one-off emergency measure, but is consistent with policies already in the works for the US, the UK, the European Union, Canada, New Zealand, and Australia. And if you have any doubts about that, you can read her other articles. Too big to fail now trumps everything. Okay, that's you, that's me, that's her, that's Spitzer, that's all the media, that's every person on the planet is now subject to too big to fail. And everybody needs to understand that. And the faster they understand that and get out of the normalcy bias of denial, the faster we can move forward in solutions to wean ourselves away from this collapse and disaster so that when it falls, it's not landing on us as best as possible. So here we go. Rather than banks being put into bankruptcy to salvage the deposits of their customers, the customers will be put into bankruptcy to save the banks. Now, this is the priority that derivatives have, and I've highlighted it just to make sure that we see it. In the U.S., after the Glass-Steagall Act was implemented in 1933, a bank could not gamble with depositors' funds for its own account. But in 1999, as we've discussed repeatedly, Clinton signed into law what was called the Citigroup Relief Act and did away with the last barrier of Glass-Steagall in 1999. And trust me, all the Congress supported it. Republicans and Democrats, it doesn't matter. The R&Ds don't matter. It's who's for the banks and who's for the people. That's what matters. Let's keep our thinking straight. So recent congressional investigations have revealed that in the biggest derivative banks, of course, JP Morgan Chase and B of A, massive commingling has occurred between their depository arms and their unregulated and highly vulnerable derivatives arms. And we saw this when they've collapsed and stole $1 billion. I can't remember right off the top of my head that recent MF Global, where all these depositors' monies disappeared. How is that? You're not supposed to mingle these accounts. They did it anyway. So they're commingling accounts. The OCC, which has been lambasted now for bailing out the banks and putting the banks in the best position at the expense of all the people and justice, is just a collusion. It's a cartel. It's a partnership. So I really wanted you to see this. Under both the Dodd-Frank Act and the 2005 Bankruptcy Act, derivative claims have super priority over all other claims, secured and unsecured, insured and uninsured. In a major derivatives fiasco, derivative claimants, she says, could well grab all the collateral. They are going to grab all the collateral. We just know that for a fact. We don't even need to have any more evidence. They will grab everything, leaving other claimants, you, public and private, that would be states, communities, anybody else, any and everybody else is at the bottom. The banks will take everything. And this is why I'm telling you, I can just feel it. And hopefully you can too, when we discover that all of the stocks and bonds that are not held in your personal name are actually under the control of the Federal Reserve. And who runs the Federal Reserve? Let's remember, it's the banks. It's a private institution owned and controlled by Citigroup and Chase, the biggest ones, plus the others. They own the Federal Reserve. So they are going to take all of the stocks and bonds. So you got to start imagining, get out of your normalcy bias, start recognizing that every account you've got in your stockbroker, every account you've got in your bank, it's going to be taken. So think about how you can protect yourself, because everybody else, we're not going to be holding the bag. We're not going to have any bags. They're going to take all the money. And so this is the point I'm trying to make. And I know it's scary. It's really scary. It can be very depressing, except now we know, and they haven't done it yet. So we can actually start to consider, okay, how do we protect ourselves? How do we move our money? What should we be doing? What should we be doing with the money? Should we stick it under the mattress? Should we put it into gold and silver? Who knows? And I'm looking for information and solid ideas. That's why tomorrow we're going to be talking specifically about public banking. And on Friday, I've got Philip Beard lined up to come and talk to us about Go Local. How can we set up a barter system? How can we set up trades? What happens when all the money's gone? Now what? Now what? And that's the thoughts and process we need to start thinking, because the more prepared we are, the less disastrous this is going to be. And the more we spread the news and the more people that are prepared, the more we can handle this kind of an explosion, because it's going to happen. Now, I really feel you must listen to this. This is Catherine Austin Fitts. I've invited her via her little video to join us today, and she is talking about the black budget. It has been very helpful for me to understand this, and it's just reality. We need to broaden our minds and recognize that this is not something we can necessarily change right now, but we need to understand it so that as we put in place things that will change the paradigm, we will know that this will be one of the things that will be locked out.
It is very, if you want to understand how things got as sort of wacky as they've gotten, you really want to dip into and try and understand what the black budget is. And one of the first things I encourage people to do if they want to explore
I apologize. For some reason,
as they've got,
there we go.
You really want to dip into and try and understand what the black budget is. And one of the first things I encourage people to do if they want to explore the black budget and what it means to our lives and the challenges of reengineering the federal financing is to look at three things. One is the the National Security Act of 1947. The second is the act that created the CIA in 1949. And then an executive order that was promulgated in 1980 when George Bush became vice president, and through the vice presidency assumed responsibility for the National Security Council, the intelligence agencies, and enforcement agencies. What the 47 and 49 Act did as in combination was it allowed appropriations to be, so Congress would appropriate to an agency like HUD, and then they could claw money out of other agency budgets for the intelligence agencies on a non-transparent basis. And presumably some of that money is overseen. It's not disclosed as a citizenry, so it's not in the budget, it's not in the financial statements. Supposedly it is disclosed to the agency, the committees overseeing the intelligence agencies in Congress. I'm skeptical as to whether they see, how much they really see, but supposedly they see some. So you have, what you did with the 47 and 49 Act was you created an infrastructure that allowed money to be secretly channeled to secret and very, from a technology standpoint, unbelievably important, powerful projects on a non-transparent basis. So there's no accountability. And one of the things I'll tell you as a former government regulator is without transparency, the shenanigans that go on, it is very hard to manage big pots of money without some kind of feedback and redundant transparency to kind of keep everybody in check. So you created this. You also did something else which is important to understand, and that is We had a fund called the Exchange Stabilization Fund. And I call the Exchange Stabilization Fund the mother of all slush funds. The Exchange Stabilization Fund is a fund under the direction of the Secretary of the Treasury, but which is managed by the New York Fed as agent. Now, the reality is it's the New York member banks who own the New York Fed, which are acting as the agent. And what the Exchange Stabilization Fund allows is completely free, unencumbered, non-transparent intervention in the financial markets and the commodities markets using the federal credit. If you take the 47 Act and the 49 Act, and then the Exchange Stabilization Fund and the operations in the Exchange Stabilization Fund, then you add one other thing, which I mentioned before, and that was in 1980 when George H.W. Bush became vice president and assumed responsibility for the National Security Council and the Intelligence Agencies and Enforcement. They promulgated an executive order that allowed private corporations to handle highly classified secret projects. So now let's take those four things in combination. What have we done? We have created a financial mechanism that can borrow as much money as it wants globally and print as much money as it wants globally using citizens' credit and the federal credit, and give that money to private corporations for the most powerful secret projects on the planet in terms of technology, and they don't have to report to anybody, and it's completely secret and non-transparent. So you have, if you're a private corporation, there's a great story in one of the books on the Bechtel Corporation about one of the Bechtel leaders trying to persuade Dwight Eisenhower that Bechtel should be allowed to own and control nuclear weapons. And Eisenhower just kind of going nuts. This was before he gave that great speech on the military-industrial complex. But you're basically creating a secret source of an infinite amount of government money to pay corporations to develop and own the most powerful weapons, technology, and space programs on the planet. And it is completely out of control and not under congressional supervision. What we have been seeing in Washington is trillions of dollars going into private corporate pockets to build and operate the most powerful weaponry in the world on a non-transparent basis. And that's why, and it was, I think, Richard Dolan who was one of the first people to promulgate the term the breakaway civilization. We have now spent 70 years pouring trillions of dollars of money and building the technology and endowment for literally a civilization which has become a breakaway civilization. We've funded them, but as I describe in my story, the leadership of the family now thinks of this money and this technology as theirs and not ours.
Makes sense, doesn't it? You remember a couple weeks ago I showed All Wars Are Bankers' Wars? Interesting thought, interesting concept. All weaponry, obviously, is decided by the bankers. They're got the slush fund, they're picking the money, they're doing what they want with it, and their trillions of dollars are being used and misused at their call and demand. They have access to all the credit creation. They own the Federal Reserve, and now they've got this slush fund. So we need to understand this, that it really is just what we say, remember on the little intro screen I have? All wars are in the end, the people are going to have to fight the banks in the end. And that was said in 1875. And that is true. That is true, and we need to recognize that this is where we're at. This is the natural and logical conclusion of allowing the creation of credit to be for private profit. So, enough about that. I really wanted to get this in today, if at all possible. I want to talk about the Trinzi v. Pagliaro. This is a classic. It's on YouTube. I'm going to play it. And there's 4 lessons that we need to learn, because a lot of you guys are still doing pro per, and even attorneys aren't necessarily that experienced in how, in court process or in these kinds of items, I swear. So let's listen. I've taken notes. That's why I've got this set here.
One of the things about the law business, the legal industry, is some of the most important things about law are actually so simple that they're easy to overlook. And there are only about 4 very simple truths. And if you know and understand these truths, you will be empowered to win. Here's the first great secret. Where does the court get its jurisdiction? We have a 2-tiered court system. There are the Supreme Courts and their tribunals. There are courts of inferior jurisdiction. When we're talking about Supreme Courts, like the United States Supreme Court and the Oklahoma Supreme Court, where did they get their jurisdiction? They get their jurisdiction because of who they are. But what about these courts of inferior jurisdiction? Where do they get their authority? The courts of inferior jurisdiction are empowered to act by pleadings sufficient to invoke their judicial authority, which means that the people, not the attorneys, the people that walk into that court empower that person in a black robe to be a judge.
Listen closely to what this guy just said. It is earth-shaking and game-changing. It puts the ball in your hands. What is he saying exactly? An injured human being has to show up in court and testify under oath that they have been injured, period. Prosecuting attorneys testify like they are the injured party, and they are not the injured party. They don't get to testify because they are not the ones injured, but they do it all the time because no one puts them in their place. Trinzi versus Pagliaro states statements of counsel in brief or an argument are not sufficient for summary judgment. If the judge doesn't like it, it's too bad. The Supreme Court, this is the Supreme Court ruling, and basically what it's saying is to the lawyer, shut up and sit down. You don't get to testify.
Jurisdiction has 4 corners on it. It's a 4-legged table. And if you take away one of those legs, it's not a court anymore. You win when you know how to invoke the court's jurisdiction, when you empower that judge to make the decision that you want that judge to make. That's the second great secret, is the Constitution, state constitutions, statutes, laws, rules. What meaning do they have as you read them in their black and white print? They don't really mean anything except a hint, a suggestion of what the law is. Well, we have a common law system. The Supreme Court tells you what that means. To find out what the law is, we have to find out what the Supreme Courts have said that that particular law means. Now, that's the second great secret. We have a means of finding out what the law is. It's written down. Where do we find the common law? It's the federal and state annotated statutes. Because, again, that's a secret. They don't want you to know that. If you can read the annotated statutes, now you know what the law is. The state annotated statutes. Those annotated statutes are going to tell me what the law is. But they're going to publish the holding. They're going to tell you the essence of that decision. And that essence of that decision, out of that case, is that one paragraph, that one sentence, or maybe just that one phrase that you need to win, and that's all you need. Trinzi versus Pagliaro is one of the most important cases that has ever been decided by the United States Supreme Court. But Trenzi versus Pagliaro is absolutely earth-shaking. The holding of Trenzi versus Pagliaro, statements of counsel in brief or argument are not sufficient for a summary judgment. Take it to heart, memorize it, get a tattoo that says that. Because that is one of the most important principles on law, in law. And that is one of the most powerful things that you will ever learn and have to use. That's according to the United States Supreme Court. But that one-fourth thing that has probably been missing 50 million times in this country when we got shafted in the court was a competent witness. Where's the competent witness? That's the fourth leg on that table. That table doesn't have four legs. That court did not have jurisdiction. Period. You've got to have somebody at some point in time before the judgment raise their hand and testify under oath and subject to cross-examination, or it's nonsense. If the other side supports their pleadings with an affidavit, which they rarely do, but if they do, you subpoena that witness because you want to question him under oath. And the idea that is the kernel of truth in Trenzi versus Pagliaro is a thread that runs through everything. Criminal, civil, it runs through everything. Administrative, it's got to be there. It's got to be there. How do I know? Here is a very good statement. And again, this is from an annotated statute. Actual facts, not mere allegations of complaint, are determinative of issue of jurisdiction. Isn't that what I just said? If there's no witness, there's no facts. If there's no facts, there's no what? No jurisdiction. It's not what I think. I think it, but it's not true because I think it. It's true because it's the law. It's the law because the Supreme Court says yes, you've got to have a competent witness to have that fourth leg on that table, or there's no jurisdiction.
So you get into a courtroom, you're sitting in court, and the prosecuting attorney stands up and he says, Mr. Johnson was caught urinating on the next-door neighbor's pet. You stand up and you say, if you're Mr. Johnson, you stand up and you say, I object, Your Honor. Trenzi versus Pagliaro. Statements of counsel in brief or an argument are not sufficient for summary judgment. See, the lawyer wasn't there. He doesn't know. He didn't see you piss on the neighbor's dog. He don't know what he's talking about. It's all hearsay. So you stand up and you object, and you do this 3 times. And on the 3rd time, if the judge doesn't catch on, you take exception to it. And then later on in the course of the legal proceedings, you bring it back to that, and it'll get tossed out. There's no doubt about it. It's a slam dunk case. This isn't my opinion. This is Supreme Court rulings. This is the most powerful thing you could ever think of. And here's the thing. It does not matter what you are in court for. It doesn't matter if you're in a criminal court. It doesn't matter if you're in a civil court. It doesn't matter if you're getting sued for money or if you're getting sued for murder, if you're getting sued. It doesn't matter what it's for. You have to have a competent witness stand up and testify and say you injured him. The lawyer doesn't get to do it. In another case, a lawyer might get up and say, Mr. Flintstone stole 72 cases of paper clips, and he's just reading from his paper there. That's when you stand up and you say, objection, Your Honor, statements of counsel in brief or an argument are not sufficient for summary judgment. It's that frickin' simple. The guy's got to sit down. He does not get to get up there and talk negatively about you. He don't know you. He doesn't get up there and get to say what an evil person you are because he has no first-hand knowledge. You can read it out of the, it's like he's reading it out of the daily newspaper. He's an idiot. And it's your job, if you want your freedom, to stand up to him and say, I object, and state Trenzi versus Pagliaro. It's that simple, folks.
All right. Some good advice that I hope we can use in especially those that are in court facing pro se. So here's another article that I will link on the comment sections. It's with regards to Trinzi v. Pagliaro, and this is some more information written that could be very helpful to those of you that really need it and can use it. I appreciate you listening today, and mull these concepts over, please. We need to do this. I'm looking at the future, and really everything we're doing is trying to save our homes, save the homes of other people, keep our money, and recognize that we can come through this together. And as we join together, we can actually make a difference. Thanks, and we'll see you tomorrow.
And the money's all spent. We're badgered from every direction. The workers get taxed while the wealthy relax. With nary a moment's reflection. Where there's grass, there's muck, and they don't give an arse, 'cause they're programmed against insurrection. And I say, bugger the bankers and politicians. Bugger the bureaucrats too. Bugger the buggers who make up the rules. And if you're one of them, bugger you. And if you're one of them, bugger you. Now all you good people with passion to vent, don't give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent by loitering